This case is about to get intense. A defendant who thought she had a deal for work release suddenly finds herself facing strict jail rules that won't bend no matter the circumstances. The judge, completely unmoved. The defense, scrambling to explain a last-minute twist that could change everything for this family. But here's the real question. Was this a misunderstanding? Or just a hard reality of the system? Stay with us, because what unfolds in this courtroom will test fairness, accountability, and just how far the law is willing to go.
At the time, she was working from home, the same type of job she has now. And that was at the time that you allowed her work release, was the exact same situation she has. I know she would like to address the court, and I know her husband here, and I think he would like to also. And I'm sorry to take the court.
Oh, go ahead.
Had me meet with a representative from work release, a gentleman who specifically asked me what I did for work, what platform, was it in person or online. He went through all of the challenges that people who work remotely incur with work release because there's 3 sets of rules that they have to follow. And at no point was anyone indicating or stating specifically that someone working remotely would be ineligible for work release. I didn't find that out until days before I was scheduled to commit. And we reorganized our lives to be able to make things, put things in place for me to be able to serve the time and have work release. So to find this out with short notice and no recourse and try to do everything is really causing more damage for our family. We really want to just do what you ordered and put this behind us, and this really makes it difficult for us to do that. I still have a family that I have to take care of. I've paid the restitution for what I did, and I want to serve the days. I'm just asking you to please allow me to do that with the sentence that you originally ordered. I'm willing to do whatever verification is necessary. If that means they need to come and do visits to verify that I'm working, that's fine. I have nothing to hide. I've been forthcoming this whole time. I just really would like the court to please consider that you gave me this privilege to begin with at sentencing. I feel like revoking it now would just be cruel.
Well, actually, I'm not revoking it. It's very clearly stated in the rules that Community Corrections went over with you that the remote employment is not permitted, and they have specific reasons. I was gracious enough to allow you work release, but if it doesn't comply with the terms and conditions of Community Corrections, I'm not going to make an exception for you because I don't see any reason. Is it a hardship on your family? I get that. Yeah. 90 days away from your family is the victims think that there's probably much more at a loss. I don't know, but that's the impression that I've been given. But
this is where things start to get critical. What the defendant is arguing here isn't about avoiding punishment, it's about how that punishment is carried out. Work release can sometimes allow individuals to maintain employment while serving time, but it comes with strict eligibility rules. And here's the key issue: remote work. Community corrections programs often prohibit it because there's no reliable way to supervise someone working from home. So even though she reorganized her entire life around this expectation, the judge is focused on consistency and enforceability, not personal hardship.
Again, I'm not going to make an exception for you in this case. There's just no reason for it.
Respectfully, Your Honor, I'm not asking for special treatment.
Well, that's exactly what you're asking for. The rules of community corrections that you went over and signed was that they do not permit remote learning. They have their reasons. I can't afford to have a probation officer go to your house every day to make sure that you're actually working and sit there with you. It just doesn't work that way. They don't have the time to do that. So I'm not going to allow it.
I don't know what rules they said that I signed. They never provided that to me. I was never told that. My own probation
Well,
officer.
again, Mr. Officer Steele back down here, who is the head of community corrections, and I'm not going to argue with you, but he's been very clear with me as far as what their rules are, that it's written in the rules. Whether you signed it or not doesn't make any difference. It's in their rules, and I'm not going to circumvent their rules and give you special privileges outside of anyone else. I handle several hundred defendants a year, and I'm not going to give you special treatment because you find yourself in a situation that you think deserves special treatment. It's not going to happen. So that's my order, and there's nothing that you're going to say today that's going to change my mind. I understand, according to Mr. Madden, this was contemplated back at the time of sentencing. I delayed taking you into custody for some period of time, and it really had nothing to do with work.
At this point, the judge draws a very clear line, and it's a powerful moment. He's not just rejecting her request, he's reinforcing a principle. The law must apply equally to everyone. From his perspective, granting her an exception would undermine the entire system he oversees. Notice how he emphasizes handling hundreds of defendants. That's his way of saying this isn't personal, it's procedural.
I gave you grace at that moment. So at this point in time, I'm not going to change the rules for you. It's not going to happen. Okay? Is there anything else, Mr. Med?
No, thank you.
Mr. Miller, do you have something you want to tell me, sir?
Yes, sir. Sir, if you can just here behind the council table so the...
Several times you made mention of here.
Yeah.
I just want to note it for the record that the victims, after your sentencing, went forth and pursued her on a civil level. Probably you don't even know.
I don't.
But they called her job, made it known, because the only time she disclosed where she worked at was in here. That was the only time it was disclosed was during the sentencing. The victims went to her job. She was employed prior to picking up this new job and made sure that they reported what happened so that she would lose that employment to cause further damage. I just want to note that our family has been through we've complied, we've done everything you asked us to do. She was able, even though that happened, she was able to secure another form of employment. The first time you came in here with sentencing, it was my understanding that you met with probation and work release to make sure that remote work was be allowed.
I did not. I did not.
Okay, well, okay. I just wanted you to know.
Okay, I appreciate. I am not aware of any civil proceedings that were filed.
Well, not civil proceedings, sir. They simply called her job, reported what happened after they obtained.
And just when you think this case couldn't get more complicated, the husband steps in and introduces a whole new dimension. Allegations that the victims contacted her workplace and caused her to lose her job. That adds a layer of real-world consequences beyond the courtroom. But here's the thing, the judge immediately shuts that down. Why? Because legally, what happens outside the courtroom doesn't change the sentence that's already been decided.
The information in your courtroom. It wasn't the only time that information was disclosed was in your courtroom. The information had actually been provided to you privately by her lawyer to you, and then they took that information and prosecuted. It's okay.
Hey, look, folks. I'm not going to get into this. What people did outside of this courtroom. You know, there was a plea agreement that was made in this case. She entered a plea of guilty. She was found guilty. I sentenced her, and I'm pretty certain that my sentence was reasonable. That's what I believe. I'm sure that the victims, and I have not spoken to any of them, but I'm going to guess that they thought my sentence was too light. I'm going to guess. You guys think my sentence was too harsh. So, you know, I try to use all available information, and again, I've been involved in youth sports in the past. I was president of the Lebanon Youth Football League. I dealt with this type of thing before. Motion. That's when I became aware that it was an issue. But that is their rules, just like when the jail has rules. And again, community corrections works under me. I understand that. Sir. But they have much more experience in supervising people than I do. I've been on the bench for 9 years, but they do the day-to-day supervision, and they come up with these rules for a reason, because they know that in the past it has caused problems. So they have these rules, and I'm not going to circumvent those rules. Just like I would not go over there and tell Sheriff Sims, Sheriff Riley how to run his jail, because they have rules over there, and they have rules over there for a reason. So I'm gonna defer to their judgment on that. Ms. Miller, did you have something else you wanted to say?
I just feel like they could have been upfront and forthcoming with that information when I met
Ma'am,
with them.
again, I don't know, again, I did not bring, Mr. Steele came down this morning for the conference. I thought this was settled. I could go get Mr. Steele and bring him back down here, and he could put on the record exactly when all this happened, when this was presented to you and stuff like that. But the bottom line is, he says, it's in the rules, they don't allow it. And again, do I have the authority to order it done anyway? Absolutely. But I'm telling you, there's nothing that you've told me that justifies me making an exception for you. The 90 days in jail was meant as a punishment, and that's what it is. So I'm not going to change the rules just for you. Okay? Anything else? All right. Thank you all.
In the end, This case comes down to one central idea: accountability versus flexibility. The judge stands firm, making it clear that punishment is meant to be difficult, not convenient. Even though the defendant complied in many ways and tried to adjust her life, the system's rules ultimately took priority over her personal situation.